shall be heard. That's it. No law of Massachusetts. This court is now open. Please be seated. Good morning.
Morning. It is freezing in here. Good morning. Welcome to the Appeals Court. Today is May 8th, 2025. We just have one case on for this panel this morning. My name is Vicki Henry. I'm delighted to be your panel chief, and my pronouns are she, hers. To my right, I'm joined by Judge Desmond. His pronouns are he, him. And to my left is Judge Englander. You are welcome to share your pronouns or not as you see fit. As I said, we have one case on for today. I understand, and that is 2024 P 351, Department of Children and Families and Others versus Mother, although I think it's actually now just Department of Children and Families versus Mother and Child. I understand you're splitting your time, 13 for the mother, 2 for the child. This is an impounded matter, so we'll just use mother and child. We won't use names. And we don't have rebuttal for better or for worse in the appeals court. I think you're veterans and know that. And with that, we can go ahead and proceed.
Thank you, Your Honors. My name is Jean Kaiser, and I represent the appellant mother. And she requests reversal of the trial court decision to modify its own order and thereby eliminate the 4 post-termination parent-child visits that it had originally ordered, and to remand the case for proper proceedings. Remand is necessary in this case for at least 2 reasons.
I'm sorry, counsel, what's the concern? We're splitting their time.
Oh, I'm sorry. Okay.
Okay, sorry. Go ahead.
First and foremost, the trial judge failed in her duty to obtain an accurate understanding of the child's current best interests regarding post-termination visits.
When are you referring to? You're saying the trial judge or the motion judge? Or
The motion judge, who was also the trial judge.
Okay.
So the trial court,
So
motion judge.
You're speaking directly to the non-evidentiary hearing now? Is that what we're talking about?
Absolutely.
Okay.
Yes, there should have been an evidentiary hearing.
I mean, potentially, but hang on. So that non-evidentiary hearing, that happened a year after the visits had actually resumed. Is that correct?
That is correct.
The visits had been ongoing for a while, then they got stopped without announcement, it appears, and then they resumed, and after they resumed for about a year, child's counsel filed a motion. Is that correct?
That is correct.
Okay, and there was a hearing on that motion.
There was a hearing on that motion, a non-evidentiary hearing.
And it's your view that that motion should have been an evidentiary hearing?
Yes, it should have been.
I understand. I know that's your view.
Right. And, well, I will now explain why it is my view. It is my view, and I think it's the law, because the trial judge had an obligation to ascertain the child's best interests at that time. And the trial court should have taken into account the effect of the improper disruption to the visits.
Perhaps. Mother was represented by counsel?
She was.
Child was represented by counsel?
That is correct.
DCF was represented by counsel?
That is correct.
Anybody object?
Nobody objected, but that does not mean that the judge did not independently have a duty to ascertain the child's best interests. When she originally decided that the child should have, it was in the child's best interest to have these 4 post-termination visits with the mother, she based that on evidence that she heard at trial. At the hearing, the motion hearing, she based it on assertions of counsel that, I believe, raised as many questions as it answered. Trial counsel, so the primary reasons that child's trial counsel, whose position is different than child's appellant counsel, gave for the termination of the visits, why they should be terminated, was number 1, that the child was having a hard time warming up to the mother. Well, that's not surprising after DCF improperly ended the visits for a year.
But the visits had resumed for over a year.
They have, but remember, there's only 4 visits per year. So that is...
3 out of 4. There were 3 visits, though, right?
There had been 3 visits, that's correct. And so it is not surprising that after a year of not visiting with the mother, and then visits that were each a few months apart from each other, that the child did have difficulty at the beginning of the visit warming up to the mother. anyone who is a grandparent or an aunt or uncle to a child, you live far away from them, you know it takes a little time when, to warm up when you first see the child again.
I mean, I don't know, that seems anecdotal. In any event, the visit stopped for the same amount of time that they had resumed, correct? They had for less a period of time
Well-
than they had resumed.
Well, a year is a very long time in the,
Was it a full year that they had stopped, or was it several months?
excuse me?
Was it a full year that the...
It was a full year that they
that
had
the
stopped.
visits had stopped? So
Right,
it was
and-
4 visits. It
Right,
was 4
correct,
visits.
correct. And so, so that would have maintained the contact. So I think the child judge was required to take into account, well, how that would have affected the resumption of
How
the
do we know the
visits.
trial judge didn't take that into account? I mean, what case do you rely on for the notion that an evidentiary hearing was required here?
Well, I think that in an instance where a judge has made an order that visits are
Judge's
in
order
the,
said four visits a year.
right, in the best interests of the child.
Although it had, well, but it had a significant caveat to it, right? That the decision could be made that it would, by the custodial party, that they would not continue those.
Well, I think that is not the correct reading of the paragraph in the order that visits could be terminated if the custodian reasonably determined, because the trial court did not do what is often done in cases where visits are left to the discretion of the legal custodian or the post-adoptive parent or the guardian. That's usually a one-sentence order.
They did it differently, but what about the reading that I just gave you is wrong? I mean, it says that they can be ceased if they determine that it's not in the best interest of the child, right?
Well, I think that if you read
Reasonably determines.
that paragraph in context with the rest of the order, that resembles very much a specific order for post-adoption visits, which judges order when they believe that when they believe that it's necessary to have such an order to protect the child's best interest. That's why they haven't entrusted the decision to the legal custodian and simply left it to their discretion. When you read it all together, it shows that the judge was ordering 4 post-termination visits.
So it seems like there's a couple of pieces to this. So let's assume that you are correct, that the judge is supposed to, it seems like the first piece is you're saying that the judge had to have had an evidentiary hearing. But well, let me back up. You're saying that the order, even though the order says it was the legal custodian's decision, you're saying no, it was the judge's decision, correct?
Yes, because, Your Honor, I will also point to the record that shows that child's counsel read it that way, that if...
Oh, I know, and it looks like DCF's counsel read it that way, too, and I have the text of the footnote from adoption of RICO, and tellingly, perhaps, that DCF does not respond to that part of your argument, which I will say, just as a general matter, I think is not a helpful appellate strategy. They do cite the case, so they can sort of say maybe, I don't know, that they met some ethical obligation, but they don't actually explain why you're wrong. So I'd find that very unhelpful, and we'll get to that with him. The next part of it is, okay, so the judge is supposed to do something. You're saying the judge is supposed to have an evidentiary hearing, but your problem is that nobody objected to the judge not having an, so now we're in this, in a criminal case, we'd say a substantial risk of a miscarriage of justice, but we're not in that context. So now what's the standard we use when the judge did something maybe that the judge shouldn't have done, but nobody objected?
Well, I think it's abuse of discretion, but I would say here the judge did abuse her discretion, because the judge relied on statements from child's counsel that, again, I'm going to say, that raised more questions than they answered. In addition to the child...
Were any of those statements incorrect?
They were not incorrect at the time.
Can I just pause? Can I just pause? I want to pause you for one moment. First, can you respond to Judge England's question, which is, what's the best case that you have that a evidentiary hearing was required? What's the best case for that?
Well, there is no specific case that addresses this specific issue. This is a kind of an unusual issue to occur. But in...
So, okay, so no case. So would it have been more appropriate for the judge from the outset to say the 4 visits are left to the discretion of the legal custodian? Maybe the language was wrong there. Maybe she shouldn't have phrased it such that it appeared to be in order. Maybe she should have said, left to the discretion.
Well, interestingly, that's what she did after the motion hearing. So I think that makes it clear that's not what she meant the first time. The first time she meant 4 post-termination visits a year.
no,
I understand the argument and the facial appeal to it, but there's other language in those orders, 7 and 8, that seems clear that it was appropriate if they reasonably determined it wasn't, the visit shouldn't continue, that they have authority to cut them off. So
So, Your Honor, I think that, as adoption of RICO says, that DCF has the power and the ability to go and seek an order if it wants to terminate. And if there's any ambiguity, and certainly there's ambiguity here, because as just mentioned, the Child's Counsel, DCF's successor counsel, and the judge herself all believed that that was an order.
And I take it you think it would be very helpful if we issued a published decision that said DCF couldn't just cut them off?
Absolutely. I think this case is a cautionary tale, because what happens here is that it's almost like an incentive for a guardian, DCF, to cut off visits that they find to be inconvenient or, not.
Well, that's not what it says. No, they can't cut it off when it's inconvenient. They have to reasonably determine that it's in the child's best interest.
Well,
I mean, why can't the judge fashion an order that is a little different than what people are used to? Yeah, we see a lot of orders that say you can do it in your discretion. It's in the we'll leave it to the discretion of whoever the custodian is. We'll leave it to the discretion of whoever the adoptive parents are. The judge chose not to do that. The judge chose to put a little bit of a thumb on the scale and say, you get 4, but the custodian, if they reasonably determine that it's not in the child, why can't they do that?
Well, I think the problem with that is who determines what's reasonable. Certainly the custodian can say, I'm being reasonable here, right? But I think when the word reasonable is used, it indicates that the custodian should come back to court, as it has, the power and the ability to do, and ask the court to take evidence about whether visits are
So
necessary.
that's reading into 9 an implicit requirement that reasonably determining it and going to court and getting a judge to say so.
Absolutely. Would it have been better if the judge was clearer?
Am I
Yes.
right that that's what you want us to do? Read into 9 an obligation to go to court.
Yes, because
Well,
I think
you're saying that the SJC already did this in RICO in
Yes.
footnote 14.
yes, because when the entire order is read together, what it does is if that one sentence is read in isolation, then the rest of the order is just really surpluses.
I understand that argument. What's different than if you say the onus should have been on the department if they wanted to exercise this reasonable language to terminate the visits, to have come back to court. And so why, if they determined based on the language that it was reasonable to terminate it, the child couldn't just move to come back to court and be like, hey, I want a hearing. I don't think that was reasonable. We should have a hearing on whether that was reasonable or not.
Well, what happened is that the child said, I don't think you can just cut off these visits, but
And the DCF agreed with that seemingly. And, well, first they said, thank you very much, and ignored it. And then down the road, somebody else, another DCF attorney, must have seen something, I don't know, I'm inferring, and the visits resumed.
right. And I think,
But my question is more pointed. My question is, had somebody determined that it was reasonable to terminate, couldn't child have some recourse by coming in and saying, we don't think that's reasonable, we want a hearing?
yes, the child could have come in, and the judge at that point should have heard an had an evidentiary hearing.
Well, maybe it's left to the discretion whether the judge thinks she needs to have an evidentiary hearing or not.
Well, I think when the judge, and again, I want to get to the point that the primary reason that was given for terminating these visits is that the foster parents didn't want them. The foster parents are not parties, not that their opinion should be disregarded.
I don't want you to think I'm not receiving that part of the argument. I get that.
And we don't know what their real position is, because all we have is the representation of counsel because there wasn't an evidentiary hearing. And that's why the evidentiary hearing is necessary.
Okay. I just had a couple quick administrative questions. Has the child been adopted?
To my knowledge, the child has not been adopted, and there is not a date for him to be
Has the
adopted.
mother been reunited with the older child?
Excuse me?
Has the mother been reunited at all with the older child? You
Uh,
had put
to-
in your brief that if she was, then we'd be back in a different loop of visitation between the siblings.
Right, well, this is outside the record that the mother is visiting with the older child.
Okay.
The child's still with the foster family?
The child is with his father, the older child.
No, I'm
He's talking about this
Oh, this child?
Yes.
This child is still with the foster family.
And what's it been now, 7 years?
Yes.
Okay. Any other questions? Okay. Thank you very much, counsel.
Good morning, Your Honors. I'm Jessica Salinas Thomas. I represent the minor child in this matter, and he is currently 7.5 years old. Thank you for allowing me this brief time this morning. The child has been consistent in his current position since November of last year, 2024. While it's a complicated matter, the trial court erred in not holding an evidentiary hearing
Consistent in what position? Consistent in what position?
in his position that he would like to have visitation with his mother. And so the trial court erred in not holding an evidentiary hearing on the motion to modify the order.
So I'm personally at a loss here, because did you file a brief that I somehow missed?
Yes, Your Honor. So I filed a brief in May of 2024
I
when the child...
apologize. Okay, thank you.
No, she then withdrew that brief and joined the mother's brief.
Okay.
So, but do you have a case that says that the judge should have held an evidentiary hearing? Do you have a case that says the judge should have held an evidentiary hearing?
I don't have anything right on point. I think in the cases that discuss modification of post-termination contact, I think in Edgar, that there were evidentiary hearings in those matters.
How do we reverse a judge who agrees to hold a hearing, has the hearing, both parties are represented at the time, all three parties, if you will, are represented at the time. No one says, hey, judge, what you're hearing is not good enough. You need to have an evidentiary hearing on this. How do we reverse a judge on that?
We're asking that it be remanded for an evidentiary hearing.
Yeah, but that's the same thing as vacating what the judge did. We're telling the judge that they didn't do it right. And it seems to me to be an awfully hard thing to do under these circumstances. That's why my first question to your sister was, got a case? Would help.
Right, and,
Did they request an evidentiary hearing? Was an
The record
evidentiary hearing denied?
the record indicates that there was no request for an evidentiary hearing at that time.
Counsel for the mother was candid in saying that at the time of the hearing, the statements of the child's counsel about the facts were not incorrect, I think was the way she put it. Do you agree with that?
I do agree, and I would also note that the statements about the child at that non-evidentiary hearing were quite sparse, according to the record. There's mention of the child not warming up, and there's mention of foster parents perhaps the placement disrupting the adoption, the planned adoption disrupting if the visits were required.
Is it fair to say that the real issue here is not how the visits with mom and the child have been going, it's mom's interaction with the foster parents?
There's only a very sparse, again, very brief mention that the foster parents had some issues. It's not clear in the record what those issues were. And I think that the foster parents' interaction with the biological mother is somewhat irrelevant to the best interest of the child. I think at this point, we're also talking about...
If she's trashing the placement or raising questions in the child's mind about, it might not be irrelevant.
But that's not in the record, Your Honor. It doesn't...
Mother says, I won't talk about the foster family. So what mother says, I won't talk, if she has the visit, she won't talk about the foster family or something like that, words to that effect. Well, why is she saying that?
I don't know. There's no indication in the record, Your Honor, about that, to my knowledge. What I would say is, again, is that that I don't think that's relevant, that their interactions or mother's interactions in the past, before the mother's rights were terminated, was relevant, and I don't think that that was the argument of...
You don't think it's relevant that the foster parents who are the pre-adoptive family for your client, right?
Correct.
May be unwilling to go through with an adoption if this order is reinstated? It's irrelevant?
I think that would definitely be tragic, Your Honor. I do have information, but it's outside the record about that, so...
No, well done. Appreciate that. I think maybe we better not, unless my colleagues think otherwise. It seems to me that it may be very relevant, but it is outside the record. And, right. Thank you.
Thank you, Your Honors.
All right. Okay, thank you very much. We'll hear from the department.
Good morning, Your Honors. William Cuttle for the Department of Children and Families. Judge Henry, I don't think I'll need all 15 minutes, but if I get close, can you please let me know?
Yes.
I'm running out of time.
They went over too, so,
Okay.
we'll keep it fair.
As a preliminary matter, I'm successor counsel on this case. My colleague retired. In reviewing the case, the department filed a supplemental record appendix, which included just a permanency report, which identified that this foster family was approved by the department as a pre-adopted family. I'm asking the court to withdraw that supplemental record. It was outside the scope of this hearing. And I think, as Judge Engler just said, it's important to focus on this actual hearing, not on factors outside of the hearing. Two important points before I answer your questions. Visitation orders are provisional in nature. RICO points that out. Evidentiary hearings are at the discretion of the judge.
I want to
There's no case that says-
stop you actually and go back, because
Okay.
one of their fundamental points is that DCF could not just terminate the visits without going back to court.
You know-
And I'm unclear what your position is on that.
My position on that, Your Honor, is, first of all, I'll answer your question directly, but it's not relevant to this hearing. But the court, if you look at the court's, at the transcript of this hearing, the court, who was the motion judge, is the trial judge. She's very familiar with this case. This is not a termination. This is just a visitation. She already terminated the mother's rights, 211 findings. She knows the case inside and out. She announced to the parties Rule 9, or Section 9, Paragraph 9 of her post-termination order, where it said that the custodian if it reasonably determines visits are not in the child's best interest, can stop the visits. Everything else that's said after that about this post-termination visits is assumptions made by folks.
Right, but that's why I'm asking this question, which is, do you think DCF, she's saying it would be very, very helpful to have a published case that says when the legal custodian at least is DCF and it has this reasonably determines language, that it has to go back to court, that DCF cannot unilaterally stop the visits.
I disagree with that.
You disagree. That's what I wanted.
100%, and I'll explain why. As we said in our brief, this judge did a very good thing in setting up this visitation order. She said custodian. She didn't say the department. This is basically.
So who do you think the custodian is?
The custodian right now is the department. The
Right.
custodian, if the child was adopted, would be the adoptive parents. When children are adopted and they have these agreements, they're called sunset provisions. They're in the position to decide whether visits can continue or not. They don't have to run back into court. This
Right,
is
but
not
there's a
during a
difference.
case.
But her whole point is there's a difference between post-termination and post-adoption visits. She's right about that, right?
Not necessarily. They're only different if that actually gets determined, Your Honor, at the adoption proceeding under
Right.
210-6. If the court wants to reevaluate the visitation order, and in this case, to be clear, the issue that the child's attorney brought up, this wasn't brought by the department. This was brought by the child. The child said the foster parents, who are now the pre-adoptive parents, are very hesitant to adopt this child if they have to have contact with the mother. And the judge said, you're saying so visits aren't in the best interest of this child any longer. And then they talked about a couple of the visits that did happen. But the main issue here, just to be completely direct, is that this child's been in this foster home almost his entire life. And at that time, the foster parents were the pre-adoptive parents. They didn't want to adopt this child if they had to deal with the mother. There had been issues in the trial.
Right, but there's a lot of ifs here. Did they then, I think this is something that I can't tell is in the record, because she argues, well, if they had agreed to adopt the child, then they would have had an opportunity to seek a different order about post-adoption visits, right? Is she right about that?
Well, they could still do that, but
Is she right about that, though?
say that again.
That if the foster parents said, let's go forward with an adoption, that they would have had an opportunity at that time to seek a different order about post-adoption visits,
You mean at the 210 Section 6 hearing?
if they were approved to adopt.
I believe that's true, but that's not necessarily to what happened at this hearing, Your
Well,
Honor.
but this is my concern, okay?
Sure.
Is until they're willing to say I do to an adoption, and
Yes.
they're in this sort of more, limbo state where they're like, if we adopt, and then you cut off the mother's visits, and then they decide not to adopt, then this consistent presence of the mother is gone, and they're gone. So it seemed to me they had to be able to say, we're adopting, if you'll let us. But it seemed like they hadn't gotten to that point. So why we're giving them this kind of power to then cut?
Because they should have more power than a mother whose rights have been terminated, Your Honor.
Well, maybe the judge should decide that, but I don't know that I don't think they do have that power where they're not making a commitment. If they're making a
Your
commitment,
Honor,
I agree with you.
Your Honor, with all due respect, you're making assumptions that are not in the record.
I'm not making any assumptions. That's her whole argument, is that we
Well,
didn't have an
her argument-
evidentiary hearing, so we don't know. And so you've left, and now the thing that I don't quite understand is that both the child and the mother want the visitation. From what I'm hearing from you, the child hasn't, or from somebody, the child hasn't been adopted, so the child continues in this limbo state. And so this doesn't seem like an ideal record for us.
Okay, can I respond?
Yes.
First of all, I want to reemphasize, this matter is not about the mother, it's about the child. Second
agree.
of all, what we're doing here today is looking at a snapshot at a hearing that took place in 2023. Everyone in this case, every party, the child, the department, not the mother, or maybe the mother, I'm not even certain about that, can go back down tomorrow and have another hearing on visitation for the current circumstances. Nothing's stopping anyone from doing that. This is all about whether, at the time of this hearing, the judge had information enough from what she heard from the child's attorney to decide to modify the order. And there's no information that was presented at that point that shows that she abused her discretion in making the decision she made at the time. You may make a different decision now, but that doesn't mean that the decision the motion judge made was incorrect
All right,
or was
so
an
let's
abuse.
assume, so let's assume all that's true.
Yes.
For the purpose of this discussion. I'd like to just revisit that window of time when the visits were stopped,
Yes,
kind of without any declaration. They were just stopped by, I assume, DCF.
yes, I believe that's true.
But what was
Yes.
going on there, and what was the recourse that mother had during that window?
Mother could have
Before
called
they
it.
resumed. I know you're going to say they resumed for a year, and then there was a
No, I'm not going
motion.
to say that. I'm going to say what the mother could, first of all, if you look at that order, the mother and the custodian, the department, were supposed to contact each other a month before the schedule of visit. The mother could call the department and say, what's up with my visits? There's no evidence that she did or didn't do that, but that was her recourse. No one,
An
no
abuse
one,
of
Your Honor,
discretion motion, right?
excuse me?
An abuse of discretion motion. Mother can go in and say, hey, the custodian, the department, has abused its discretion here, Judge, because they didn't have a good reason to
That's right.
to stop. So
That's right.
she had that available to her.
Your Honor, no one did anything for that year. And of course, it was around COVID, too, so I'm sure the world was different then, but the mother didn't do anything, the child didn't do anything, the department didn't do anything to change the visits.
But that's the part of RICO I don't, and please correct me if I'm wrong, I welcome it. But the footnote in RICO says specifically, and I'm quoting, "We reject the suggestion, if it's being made, that in a proceeding in which the court terminates parental rights and leaves custody of the child with the DCF, the judge may not, or at least should not, enter an order requiring visitation between a child and his biological parents unless DCF is shown, presumably on a later motion by the child, to have abused its discretion in refusing visitation." And they don't want to leave it on the child, because the child at that point is the only one who has counsel, the parents aren't going to have counsel, to come back in. They want the judge to exercise their discretion and their supervision over DCF. Is that wrong?
Well, I don't think I think the judge in this case handled that circumstance in her way. She made an order. Everyone says that this order isn't clear. Paragraph 9 is crystal clear. The mother doesn't just like what it says.
Right, but this is, okay, so you don't agree that we have to read that paragraph in the context of adoption of RICO. You think the department did not need to go to court and they could just make a decision to terminate without any supervision?
In these circumstances, if it was before termination, Your Honor, the department, under our regulations, has an obligation. If we're going to stop visits, we're supposed to go to the court and do
Right,
that.
but you're saying post-termination, you don't need to go to the court?
That's the case. And just, I don't want to lose the point, because it's easy for me, maybe for all of us, to get swept up in the different issues here. But I want to really focus your attention on the moment at the hearing, not before, not after. Because whether the visit should have happened or shouldn't have happened, it's not relevant to what happened at the hearing, no matter what the mother says. It's not.
So what's your best case for the idea that the judge did not need to have an evidentiary hearing?
Rico, Mark, Theodore, they all say it. Edgar. Rico, at the end of the Rico decision, they remanded the case back, and Judge Bartford said that the trial judge may decide whether to hold an evidentiary hearing. That's their decision. It's clear as a bell.
So, having been suitably advised that we need to focus on the events of that time, I'm now going to ask you a question about events after. But I've been suitably advised. 2 years, right, since the order entered in this case.
Yes.
In those 2 years, there have been no visitations between mother and child?
I don't believe they have, Your Honor, but I'm not 100% certain, but I don't believe they have.
All right,
And in those 2 years, there's been no adoption?
There is no adoption. And I'm not going to get into.
No, that's right.
But
Literally all I wanted to know.
Okay, thank you.
Okay.
Yes.
I know that at one, well, I believe at one point
Judge Desmond, I can't hear you well.
I'm sorry, I believe at one point the foster family was reluctant to move toward adoption because they wanted to adopt a different sibling
Yes.
children. Is that correct?
Yes.
And
yes.
the record suggests that they've moved away from that and are now considering adopting this child. Is that fair to say?
Yes, that's, I think in our brief, and everyone's, I mean, that's what was presented at that hearing, that the foster parents at the time had informed the department that they were interested in adopting the child again, but were reluctant based on the visits.
And then the visits have stopped, but they haven't adopted the child.
Say that again, Your Honor?
Visits have stopped, and they have not adopted the child.
Not as of yet, no.
Is there a proceeding to adopt the child?
I mean, is there something scheduled? I don't know that. I will tell you this without talking about specifics, because I think it's important to inform this court. I spent a good part of my day yesterday talking to the adoption people for the department about this case.
Who are the
And-
adoption people? What does
You're
that
at
mean?
1.5 minutes, although I suspect we're about to go over, but in any event.
All the matters that have to do with this child, whether he's adopted or not by this family, whether visits should continue or not, all can be addressed below and should be addressed below going forward, because
Right,
now,
but-
with as Judge Englander pointed out, 2 years have gone by.
Right, but you're
And these are-
saying they could have gone back any time to reestablish visits. I take it that the other side is true too, that they could have moved forward with an adoption any time in this
You
interval?
can't move forward, you can't move forward with an adoption until you have a family that's ready to do so.
Okay.
And
So sometimes the trial courts will, they can be a little broad actually in saying, well, we can't enter any orders because there's an appeal pending. But you're saying that if they go into court this afternoon or tomorrow and ask for the visits to be resumed, the department is not going to take the position that they can't do that because this appeal is pending. A lot of knots in there.
No, I believe they can't do that. I mean.
You think they can?
I think they cannot.
I thought earlier you said they could.
No, I believe they can go back. They can go back. The department.
You mean the department can't take the position that they can't go back? That's what you were trying to say?
right.
Yeah. Because this is a limited appeal. This is just has to do with this
Yes, Your
order.
Honor. And just, I feel very strongly about this. It's important. It's important for the department and for the child and for all involved parties to go back down and re-explore the current circumstances for this child. But that has nothing to do with what happened at the hearing on April 11th, 2023. That motion judge, who was a child judge, heard that the foster parents were now interested in adopting this child who they've had in their care for, at that time, for 5 years. And the judge, it's not what I think, it's what I read, which is the judge was concerned about the best interests of this child. And that's what this court should be concerned about. That's what we all should be concerned about. No disrespect to the mother, but her rights were terminated. Visits with parents are basically to help a child go forward, not for the parent.
Okay, so we're a minute over time, but we have more questions.
So you say you feel strongly that the matter should be revisited in the trial court. Is that what I heard you say?
Yes, but I don't want to admit, thank you for, this case should be affirmed here.
I get it. So
Okay.
now I want to ask, so what's the vehicle to get it back into the trial court for a hearing?
The case is still in the trial court.
So you're going to move for a hearing?
Am I?
I'm asking you.
Uh,
You feel strongly about it, so
You know
yeah,
what?
you're going to move
You
for a
know
hearing?
what? Yes, I am. I'm going to talk to my people, the agency. I want this case resolved with this child. It's very important.
There it is.
But that's,
But
I understand, I understand.
So,
That doesn't go to the merits of this argument that we're talking
Correct.
about today. I
Correct.
understand.
right, and we have plenty of work. So if everybody thinks that this should get a hearing under the current circumstances, then why are we here?
Because this appeal was brought before you, Your Honor.
Yes, but you could moot the appeal if you all went back, and particularly if
again?
you could moot the appeal if you all agreed on something, or if you all went back and got a quick hearing.
I've been doing this for 22 years, and I don't make excuses. I think you know me a little bit. I just got this case, okay? And as you can tell from the tone of my voice, I'm very animated about this case. So I understand why you're saying, why is it before you? But it is.
Is this your animated tone?
Yes, because I'm before three justices.
I thought you were animated.
Courtroom.
Can I go on record as saying I thought you were animated, based on my prior experience, counsel?
Judge Igleton, you know when I'm animated, right?
You're animated, babe.
I just want to, and I'll stop. You can hear that you can decide this particular issue, affirm what the motion judge did, and the case everything could be resolved below by the parties. That's my take for the department. Thank you.
Okay. Thank you very much. The case is submitted. We understand your positions. I want to thank the staff for assisting us in getting everything ready for today.
Thanks to everybody. These are hard cases.